May please, Your Lordship. Your Lordship, I beg to mention item number 3 on the daily list, Your Lordship.
Number 3.
Lordship, I humbly pray that the matter may be taken up after 2 weeks, Your Lordship.
I think the other side have already started.
Yes, Your Lordship. It's a part heard matter.
Part heard. So once it is part heard, it becomes very difficult. We can adjourn it till the next 1 week, 2 weeks. But if you go on till after 2 weeks thereafter, then you have to start again. Yes, what did you say?
I have no objection, Your Lordship. And Your Lordship, I beg to submit that we have made the necessary correction in the paper book.
Oh, that is the case.
Yes.
On pre-made by the respondent. Respondent number?
The respondent number 1 and 2, Your Lordship.
Respondent number 1.
I'm put on 3.
Respondent number 1 and 2, Your Lordship.
Respondent number 1 and 2. Seeking accommodation on grounds of personal difficulty of the learned counsel. The same not being objected to by the learned counsel of the appellant. Matters adjourned. List is stay after 2 weeks.
Much obliged, Your Lordship.
On daily list, item number 1.
Today only the miss case has been listed. So may I pray that the main case is also coming up on 25th of April. So
Main case?
yes, my
Why
lord. Miss case for stay of the impugn order, my lord.
Stay of the impugn?
Impugn judgment, my lord. In the main case, notice has been issued on 27/3/2025.
Oh, none. Last time none appears.
Last time none appears, my lord. I'm very sorry, my lord.
On pre-made parties, list this matter on 25th.
Obliged, my lord.
Item number 2.
Dividend, right? Yes.
Picking the phone.
If this matter is fixed for affidavit by the respondents.
On behalf of 1 to 5, we are not filing any affidavit. 1 to 6.
On behalf of 7 to 10, we will be filing.
This is a matter, my lord, by which the complaint against the CM of Milliam has been dismissed by the executive committee.
The same of
the complaint.
Okay.
There was a complaint.
Present CM.
Yes, there was a complaint filed against the present CM, and the executive committee was pleased to, after hearing the parties, after inquiry, was pleased to dismiss the complaint. They have come against that.
We are challenging the order passed by the Deputy CEM, my lord, of KHADC.
But you are not filing any counter?
No, we did not file a counter, my lord. They may have to file.
Who are you?
I represent the scheme from 7 to 10, Your Lordship.
Mr. Learned Counsel for the respondent 7 to 10 has once again sought for some more time to file the counter affidavit. I am Ashwaigatu, I, Mr. T.T. Dingro, Learned Senior Counsel, appearing for the respondent 1 to 6 of the KHADC, has submitted that no counter affidavit would be filed on behalf of such respondent. Nangtas I have to go away. On pre-made, the same is allowed. How long? How long would it take? 3 weeks. On pre-made, this is matter of the 3 weeks.
Item number 4.
Second call, my lord.
Pass over.
Item number 5.
May it please, Your Lordship. Lordship, this matter may be closed, Your Lordship, as the matter has become infructuous, Your Lordship. These villages where they have addressed their grievances, Your Lordship, before the block, these villages has been transferred to another block, Your Lordship.
Okay.
Yes, Your Lordship. So I have a very small prayer, Your Lordship, with regard to the two writ petitions, 135 and 136. They are pending work orders, Your Lordship, with regard to 135 and 136. 135, we've almost completed the work. My prayer is that, Your Lordship, if there are any pending dues before the state government, those pending dues may be released, Your Lordship, if there is any, Your Lordship.
Well, the matter has to be heard then. If that is the case,
Lordship.
then the matter has to be heard.
No, Lordship, work order has already been given to us, Your Lordship.
Then what is your initial prayer? That has to be addressed.
Lordship.
This matter become infructuous and
Now,
this
since
may
you
be
say
closed
that
with
it
the
has
liberty
become
to file
infructuous.
afresh.
Yes, Lordship.
If you are aggrieved by any subsequent action on the part of the authorities, then you have another course of action too.
Lordship.
That is up to you. You cannot, tag such prayers along with the
No, because that is the interim prayer in these two writ petitions, Your Lordship.
interim prayer.
Interim prayers, Your Lordship.
Your Lordship, see, this matter become infructuous, so this matter may be closed with the liberty to file afresh. If there's a fresh course of action.
There are
No, Lordship, because the work orders which was issued to the villages, Your Lordship, this is with regard to this same block, Your Lordship. I'm not saying that the state has not released. The state has released, Lordship. We don't have anything against the state or against anybody, Your Lordship. So my only grievance here, or my only submission before Your Lordship, is that if there is any pending dues, Your Lordship,
that is for you to pursue. You cannot compel the court to
Liberty, you take liberty.
to act on your behalf. Your submission is the matter has become infructuous. You have no grievance against the respondents.
Lordship.
Whatever the case be, the work is ongoing or still proceeding. If at all you feel, as I said earlier, if you feel aggrieved by any subsequent action or inaction of the respondent, then you can always come approach this court or approach the authorities concerned.
All right, Your Lordship.
And if they fail to address your grievance or concern, then you are at liberty to approach this court. So we'll just dispose it off as infructuous.
Lordship.
Mr. Epagante, learned counsel for the petitioner, has submitted that this petition may be disposed of as infructuous. Accordingly, on prayer being made, this petition is hereby dismissed as infructuous.
Hello, Blech, Your Lordship.
So this is
5 to 9.
5 to 9.
Yes, Your Lordship.
5 to 9.
Hello, Blech.
Second call, item number 4.
Perlu himogate.
Date is also there. Mr. Karmik is also there.
Who?
I'm for the private respondent.
Oh,
He's
private.
probably on legs in the other court, my lord.
I can start, my lord. He can join.
Yes, please.
My lord, this is a review petition. A review, my lord, based on a very, very limited ground, my lord. A review not based on facts, a review not based on any merits, my lord, a review based on a pure question of law, my lord. Just to explain what or what has necessitated this review, if lordship looks at page 17,
does it fits within the contours of
it does, my lord. 47 order 47.
47.
It does, my lord. I'll substantiate. Page 17 of the review petition may kindly be looked at, my lord.
Yes.
Page 70, my lord, is the writ petition which was filed originally. In this writ petition, there is only one vague averment in respect of the advertisement in question, my lord. That averment is at page 29. Page 29, the second paragraph.
Page 29.
Second paragraph, that the petitioner states that from so and so. That is para 10, I think. I'll read, my lord. That the petitioner states that from the given circumstances, it appears as if the advertisement dated so and so was perhaps issued in order to suit the qualifications of the private respondent number 9, Srimati so and so, that is me. Even if it is assumed that the said advertisement was to fill the vacant post of ASME's teacher in the said school, it may however be stated that the interview board constituted via memo number so and so, annexure so and so, appears to have been constituted. It goes on. What I'm requesting Honorable Court to focus on is the fact that there is an averment. The only averment in the writ petition in respect of the advertisement in question is this. And what the nature of the averment may kindly be looked at. The nature of the averment is, it is less an averment, it is more an innuendo. It says that it appears as if the advertisement dated so and so was perhaps issued in order to suit the qualification of the private respondent. So certainty in that averment is missing, precision in that averment is missing. Point is, my lord, this is the only averment in the writ petition in respect of the advertisement. Page 38, my lord, may kindly look at annexure 3. This is the affidavit filed by the state respondents. Page 38. Perusal of annexure 3, the affidavit will show there is no mention of the advertisement.
Yes. This is state respondent.
State respondents. Page thereafter, my lord, page 52. Page 52 is my affidavit in the writ proceeding, my lord.
Yes.
Perusal of my affidavit will also show
Yes.
that there is no mention of the advertisement. Now, before proceeding further, I will seek Lordship's permission to humbly submit that the reason I state as to why there is no mention of the advertisement in my affidavit or the state respondent's affidavit is for the reason that the advertisement was never in question. The advertisement was not challenged, the advertisement was not rebutted, the advertisement was not questioned, etc. in any manner besides that one line mentioned in the writ petition. So therefore there was no reason, there was no chance, there was no occasion for any of the respondents, including me, to have raised any sort of or given any sort of answer in respect of that advertisement, given any sort of response in respect of the advertisement. Page 64 may kindly be looked at. Page 64 is the rejoinder filed by writ petitioner against my affidavit. Page 64, the rejoinder affidavit is also silent on the advertisement. Now, the pleadings were completed after the filing of this rejoinder. My attempt, the reason I've taken my lord through the pleadings is only to show that the pleadings did not challenge the advertisement. There was no question raised about the advertisement. There was no specific challenge raised against the advertisement. Now, matter proceeded in the earlier round, leading to the judgment being passed by this Honorable Court. That is at page 87, my lord.
Yes.
Now, page 87 is the judgment. If Lordship kindly looks at page 91, para 12.
Yes.
Para 12, my lord, if I'm allowed to read. Yet another contention raised by the learned counsel for the petitioner, that means the writ petitioner, is that the said post was advertised on so-and-so only with the aim to facilitate the application of the respondent number 9, inasmuch as the vacancy arose on so-and-so on the demise of the incumbent teacher, but the advertisement was issued only on so-and-so a day after the wedding of the son of the secretary of the said school to the respondent number 9, even though she does not have B.Ed as her qualification. So, in spite of the fact that in the writ petition there was only a one-line mention of the advertisement, during the hearing, the counsel of the petitioner raised the point of the advertisement. His point was that the advertisement appears to be a manipulated exercise, inasmuch as it was issued one day after my marriage with the son of the secretary of the school. Now, Lordship, that is neither here nor there, my lord. It was issued one day after, or 2 days after, or one day prior. That cannot form the basis of a judicial adjudication. In any event, this was the only submission, oral submission made in respect of the advertisement. Page 95 may be looked at.
Yes.
Now, page 95, para 21, the senior counsel who had appeared on my behalf, review petitioner's behalf, had made the submission. I'll read, my lord. The second challenge of the petitioner to the selection process is that the advertisement was custom made to suit the candidature of the respondent number 9. However, here too, the learned senior counsel has submitted that without challenging the advertisement itself, the entire process which emanated from the said advertisement cannot be challenged. So, there was a contention raised at the time of hearing that it was a manipulated advertisement. Senior counsel appearing on my behalf in the first round submitted very correctly that without challenging the advertisement, without there being a prayer in the writ petition in respect of the advertisement to set it aside, etc., the entire process which has come out from the advertisement cannot be set aside by setting aside the advertisement itself. Subsequent to that, if Lordship kindly looks at para 49, that is at page 106.
Yes.
Para 49. I'll read you. This was the finding of this Honorable Court.
Yes.
On an overview of the case of the parties herein, this court is convinced that the said advertisement dated so-and-so is an erroneous one and cannot be allowed to be acted upon. Consequently, no right has accrued to either of the parties involved as far as the same is concerned. The advertisement dated so-and-so, published in newspaper on so-and-so, is hereby set aside and quashed. The whole selection process thereto is now brought to naught. Consequently, the recommendation and appointment of the respondent number 9 also stands quashed automatically. The interim order passed in this connection is hereby made absolute. The school authority managing committee is directed to issue fresh advertisement for the post, however, in accordance with the prevailing rules and regulations as regards appointment of an assistant teacher in deficient higher secondary schools of the state. Petition disposed of. Lordship has set aside the advertisement. Consequent to the setting aside of the advertisement, the entire selection process has, as Lordship has observed, has come to a knot, my Lord. Now, my limited request in this, through this review petition, is for this Honourable Court to kindly appreciate that the advertisement was never under challenge, my Lord. Not being under challenge, none of the parties, including me, had any opportunity or reason to try and convince this Honourable Court as to the legality or the validity or the propriety of that advertisement. So, not having been given the chance to meet that question, to answer that question, and having the advertisement set aside without being afforded the opportunity to convince this Honourable Court otherwise, has led to prejudice, has led to Lordship will forgive me for pointing this out, of somewhat failure of justice, for the reason that the advertisement was not in challenge, my Lord. Now, the law on this point, Lordship is very well aware, is very well settled. On the previous occasion, I had submitted a judgment, but copies are still available. This is from 2022 Supreme Court.
Yes.
Para 16 of this judgment, my Lord.
Para 16.
1/6.
Yes.
I'll read, my Lord. Coming to address the second issue, while this court is not apathetic to the predicament of the respondent grandparents, it is a fact that absolutely no relief was ever sought by them for the change of surname of the child to that of first husband, son of respondents. It is settled law that relief not found on pleadings should not be granted. If a court considers or grants a relief for which no prayer or pleading was made, depriving the respondent of an opportunity to oppose or resist such relief, it would lead to miscarriage of justice. In the case of Trojan and Company Limited versus so-and-so, this court considered the issue as to whether relief not asked for by a party could be granted, and that too without having proper pleadings. This court held as under, it is well settled that the decision of a case cannot be based on grounds outside the pleadings of the parties, and it is the case pleaded that has to be found. Without an amendment of the plaint, the court was not entitled to grant the relief not asked for, and no prayer was ever made to amend the plaint so as to incorporate in it an alternative case. In the case of Bharat Amritlal so-and-so versus so-and-so, it was held. Though the court has very wide discretion in granting relief, the court, however, cannot, ignoring and keeping aside the norms and principles governing grant of relief, granted relief not even prayed for by the petitioner. So that is the sum total of my limited review, that I'm seeking. A relief that was not asked for, a relief that was not pleaded, a relief that was not answered by any of the respondents. With respect, I need to point this out, should not or could not have been granted by this Honourable Court. So that is the limited ground of relief of relief that I'm seeking through this review petition. To answer Lordship's first query as to whether what I'm seeking is covered under Order 47, if Lordship kindly allows me to open Order 47. Order 47, my Lord, sub-rule 1, my Lord. I'll read, my Lord.
Yes.
On any person considering himself aggrieved, A, by a decree or order from which an appeal is allowed but from which no appeal has been preferred, B, by a decree or order from which no appeal is allowed, or C, by a decision on a reference from a court of small causes and who, from the discovery of new and important matter or evidence which, after the exercise of due diligence, was not within his knowledge or could not be produced by him at the time when the decree was passed or order made, or on account of some mistake or error apparent on the face of the record, or for any other sufficient reason, desires to obtain a review of the decree passed or order made against him, may apply for a review of judgment to the court which passed the decree or made the order. So, my lord, two things, my lord. If a person considers himself aggrieved, which I do, by a decree or order from which an appeal is allowed, but from which no appeal has been preferred. So, till date, my lord, this lordship's judgment has not been challenged under any appeal. And the grounds of review are listed out, my lord. The grounds of review which could apply in this case are two, my lord. Two broad grounds. One is, with respect, my lord, if there is a mistake or error apparent on the face of the record. So on the face of the record would be which does not require an elaborate process of examination. But from the face of the record, from the pleadings which did not challenge the advertisement, but read with the judgment of lordship's judgment, which has set aside the advertisement in spite of there not being any challenge. With respect, my lord, it may be considered to have been I hesitate to use the word, but a mistake committed by this honorable court, or for any other sufficient reason. That is, I would say, wide enough to cover my case also, my lord. So, my lord, as I said, I am not on any merits of the matter. I am not trying to re-agitate or have a second bite of the apple through this review petition. I am only on a very limited point that a relief which was not sought for or which was not agitated should not and could not have been granted, and therefore this review may kindly be allowed, my lord.
What was the relief claimed by the petitioner?
Yes, my lord. If lordship kindly looks at page 32. Page 32, my lord. In the prayer portion, my lord, last, in the given facts and circumstances, it is prayed that this honorable court may kindly be pleased to issue rule, admit this instant writ petition, and issue notice to the respondents to show cause as to why the rule should not be made absolute and or the reliefs claimed by the petitioner should not be granted, and on being satisfied, this honorable court may be pleased to quash and set aside the impugned order number so-and-so, dated so-and-so, appointing the private respondent number 9 as the assistant teacher, Arts, Rajbala so-and-so school, and approval granted by the Office of the Director of School Education and Literacy, Meghalaya, Shillong, vide letter number so-and-so, as the same is in gross violation of the provisions of law and the directions of the Government of Meghalaya. Supplementary prayer, and may further be pleased to appoint the petitioner and or may kindly direct the concerned respondent authorities to appoint the petitioner in the post of the assistant teacher so-and-so, so-and-so, so-and-so. So, my lord, there were two prayers. One, to set aside my appointment, and consequently to appoint the petitioner, or to direct the respondents to appoint the petitioner, my lord.
And how was your appointment occasion?
Through this impugned letter, my lord. Through this
letter, no doubt. What was the process that was carried out prior to the
issuance of this? Prior to the issuance, there was interview conducted. There was a test conducted. There was interview.
So the genesis is the advertisement. The genesis is the advertisement.
The genesis is the advertisement. No, my lord will kindly consider a situation where, for example, there was no illegality that could be found with the advertisement. So the advertisement stood. Events transpiring after the advertisement, the interview, the selection process, and the selection itself was put under challenge by a concerned person. And honorable court found merit in the matter and set aside the selection. Advertisement can stand, my lord. Advertisement can stand. My point is, my lord, that if you've challenged the selection process, well and good, honorable court will decide on that, on the selection itself. But if your challenge is based right to the root, it goes right to the root, and you're challenging or raising questions about the advertisement itself, then you need to plead it, number one. Number two, my lord, naturally we have to be given the chance to respond to that pleading, etc. That did not happen in this case, my lord. The selection process has been set aside, well and good. There may be merit in that. I'm not on that, my lord.
See, Mr. Jindal.
Yes, ma'am.
Like you said, I would also admit.
Yes, ma'am.
See, the court may be wrong.
My lord.
In all
My lord,
probability is,
my lord,
more often than not it's wrong. Therefore,
No.
we have higher courts.
my lord.
That's a settled position.
Absolutely, my lord, absolutely.
But if the court has taken into consideration the gamut of the whole process,
Yes, my lord.
now what is perceived?
My lord.
Again, you see, you are at liberty to challenge that, but what is perceived as a wrong being committed
Yes, my lord.
at the first instance
Yes, my lord.
cannot be righted by another wrong.
I would agree on a general principle. Yes, I would agree, my lord.
That wrong would be the impugned order of appointment.
Of appointment,
So to
my
say.
lord. Of appointment.
So, I don't know. Where's your scope of? You could very well have gone on appeal.
My lord, that the option to appeal was available. The option to appeal was available, but
So, yes, that is available to you.
the option to appeal was
The High
available.
Court, like I said, the High Court would have set the matter right if
My
it
lord,
finds that they,
my lord, the option to appeal was available, but the option to review was also available, my lord.
True.
So, choosing one of the two, we've chosen this particular route, and I would submit, my lord, the
Going for review is,
no, it's
trampling on very thin ice.
it is on thin ice. It's an uphill task. I understand the torturous nature of the task, my lord. To convince a court that court was wrong, my lord, it is it is difficult. But my lord, I think the records speak for themselves, my lord. In this case,
that is why.
the records speak for themselves.
That is why we have
Yes,
see, the law laid down.
Yes, my lord.
That anything that is apparent,
Yes, my lord. Yes, my lord.
apparently wrong on the face of
Yes,
the
my
court,
lord. Yes, my lord.
needing, like you rightly pointed out,
Yes, my lord.
needing no further investigation,
Yes, my lord.
or in-depth study, whatever the case may
Yes,
be.
my lord.
That,
Yes, my lord.
but I don't know.
So
Of course.
my lord, I have to bow down to what lordship has said, and I leave it to lordship's good judgment as to whether this would be a fit case to exercise lordship's power of review. I've pointed out what appears to be an again, I hesitate to use the word, but an error in the judgment. If lordship is convinced that this could be a ground or a reason to review the judgment, we'll leave it up to lordship's good judgment.
We'll see. The court will look into it.
Yes, ma'am.
But again, off the record, I would say you have a good case for appeal.
Off the record, I will agree, my lord. But
you have not.
Off the record, I will also agree. But having chosen this path, my lord, we are bound to travel this path, whatever destination is reached, my lord, at the end, if lordship allows or does not allow, my lord. I leave it to lordship's good wisdom. My lord.
Sometimes these are just futile exercise.
This we were under the impression that this would be a little more easier process to review rather than appeal. Circumstances have proved us wrong because we've struggled to get this heard. Finally, it's
Save your stamp duty.
hardly, my lord, hardly, my lord.
Yes.
We leave it up to my lord.
Who's?
Firstly, I was the petitioner in that case, my lord. Now, my lord, firstly, my friend on the other occasion had stated that his submission is all over. The submission is to be given by us. Nevertheless, my lord, he has given his submission.
It's good
My
because
lord,
it's refreshing the court's mind.
He's my lord, gone into the merits of the case. Now, my lord will firstly see this review. It is not maintainable. But before going to that, my lord will kindly see. Pursuant to the directions of this honorable court, there was an advertisement issued. My lord, the petitioner, review petitioner hearing filed her, my lord, application, then received her call letter also, my lord. So that selection, thereafter the selection process went ahead, pursuant to the directions of this honorable court. Thereafter, a new candidate is already joined, my lord. So here the third party right is
So you
definitely
mean to
there.
say that pursuant to the order passed by this court,
Yes.
advertisement was floated,
Yes.
to which the review petitioner had applied,
Herself applied.
went through the process,
Yes.
was not selected.
My lord, till yes, we can say that, my lord.
No, the selection process is complete or not?
Selection process is complete. Teacher has already joined.
Only joined.
Yes.
So
he is serving also.
Therefore, she was not considered.
Secondly, my lord, the grounds which are raised in the review, my lord, all these grounds can only be raised in appeal, my lord. My lord, my friend has gone through the judgment. My lord, this honorable court has exercised its full, my lord, full power, equity,
Consideration.
discretion,
equity, fairness and justice, all these factors are already taken into consideration. In fact, those observations which my friend are raising now is already there in the order, my lord. What remains to be reviewed? There is nothing at all. So this review is actually an afterthought. There was no intention to file a review, my lord, because the petitioner was somewhere, review petitioner was somewhere expecting that, she will get the job again, my lord. But perhaps at some point of time realized that she will not be able to. Then she turned to this review, my lord. Now, my lord will kindly go through the grounds. What are the grounds? These are the grounds that can only be raised in appeal, my lord. Where is the error apparent? My lord, this court has at length heard the matter of all the parties, going through the affidavits, rejoinders, all sorts of objections were raised. My lord, my friend was also there. My lord, he had also stated that the position of the law is that you have to, although the affidavit was otherwise, but my friend considered before this honorable court that there was a mistake committed even by the government while giving the approval, because it could not have been given approval because the qualification which is laid down, this is mandatory. So that my friend also fairly considered, my lord. Had the court taken this view, my lord, the court could have taken a different view, saying that, okay, your appointment is quashed. Now the petitioner, that is me, is appointed, direction for appointment. But in all fairness, my lord, this honorable court thought it perfect or true to dismiss this instant, my lord, to quash and set aside the whole process, my lord. This is in terms of equity and fairness and justice. So this decision has already been taken by this honorable court. He cannot go for a rehearing of this whole matter. All these matters have been at length discussed, my lord, at length argued. We have filed written arguments, judgments, everything. After thorough consideration, this honorable court has come to the decision, my lord, and there is no fault in that. That cannot be faulted with. And in this review, my lord, the review petitioner is trying to do fault finding in the order of this honorable court. My lord, the advertisement is dated, the honorable court's order was dated 26/2023. Advertisement was issued on 23/8/2023. Then thereafter, review was filed on 24/11/2023. So merely going into the merits of the case and trying to impress upon this honorable
When
court.
was the order passed with this court? 20?
My lord, that was 26/2023.
26.
20 in the month of June.
2023.
20/06/2023.
Advertisement on?
Advertisement was issued on 23/8/2023.
23/8/2023. This review petition?
Review petition was filed in the month of November, my lord, 24/11/2023.
24/11/2023. See, you have to satisfy this court,
my lord,
as far as the contention of the petitioner is concerned,
my lord,
that the advertisement in question was never an issue in the writ petition. There was no reference made to it, barring a few stray references. And number two, there was no particular pleading as far as the advertisement is concerned, whether it's correct, not correct,
my lord, will
proper, not proper, all those things. And there's no specific prayer.
My lord will kindly see. My lord, these very points are already argued. Same points cannot be argued again in a review, my lord. These same points, that is exactly why it is also reflected in this honorable court's order, my lord. This, my lord will kindly see. My lord was right. What is the genesis of the appointment of the review petitioner here is the advertisement, my lord. It is sufficient for me to pray for quashing of the appointment orders and the approval orders. That itself serves my purpose, my lord. It is sufficient for me, even if I don't challenge the advertisement. My lord, because I was naturally in the writ petition, I was hoping that I will get appointment, my lord. My grievance was naturally in the advertisement itself, that averment itself is there. It is not that I have not made any statement that this could be the conclusion, but that averment is clearly there, so that it suits. And of course, the events that I have narrated, I have already narrated before this honorable court in the earlier occasion, my lord, and the hearing for the writ petition was taken up. So the genesis is the advertisement, my lord. If there is no advertisement, there is no appointment. So even if I don't, assuming that I don't challenge the advertisement, still it does not affect anything. It's my appointment. If this honorable court had taken a decision that yes, appointment of the review petitioner and the approval order stands cancelled, what would be the next position, my lord? So either I would have to be given the appointment, because that was my prayer before this honorable court. But in all fairness, this honorable court decided that no, might as well scrap this whole thing. Let there be a fresh selection process. And this honorable court has wide discretion, my lord. There are several. My friend has placed one judgment, but there are several judgments, my lord, of the honorable Supreme Court. Of course, I don't have it today, which
should have been.
I will supply it, my lord, because I'll file a written argument and I'll supply the judgments also, my lord, which gives ample power to this honorable court. The aim is justice and equity, my lord. That is to be upheld. That is to be upheld by this. That is why we have approached this honorable court, my lord.
See how justice is to come about. See that itself, is to be looked into.
If we take my friend's argument that the advertisement was never challenged, if that is so, then my lord, okay, fine. Then what remains is that the review petitioner's appointment and the approval goes. So then I benefit then. If that is the case, then appointment should be given to me, because that was the very prayer in my writ petition, my lord. That was the very prayer. But for some reason, this honorable court came to a conclusion that even I cannot be appointed. So that being the scenario, the selection process is over, the appointment is quashed. What remains? Naturally, the outcome has to be a fresh process, my lord. Had this honorable court come to a conclusion that I am fit, I should be appointed, then there would have been a direction by this honorable court that okay, you quash these two, appointment and approval order is quashed, petitioner with a direction that you appoint the petitioner. So I don't know how it benefits. And only, my lord, if I am allowed to take through the grounds, my lord. What are the grounds? These are all the grounds that can be raised in only an appeal, my lord. Because it tries to show that there was an erroneous, merely mentioning that error apparent on the face of the record will not be sufficient, my lord. All the pleadings say that there is this decision is erroneous. That is what it points.
Yes.
My lord, I'll start reading from grounds, my lord, page 11. Para 2 onwards, my lord. Para 1, he's stated that error apparent on face of record. This is just a mere submission, my lord. For para 2 onwards, I'll read, my lord.
Yes.
For that, it is tried law that court cannot grant a relief which has not been asked for. As it is evident from the writ petition, there was no relief claimed vis-a-vis quashing of the advertisement dated 6/1/2015, and in the absence of any prayer made and relief claimed as against the advertisement dated 6/1/2015, the said advertisement could not have been interfered with in any manner whatsoever. So you, my lord, will kindly see the grounds. As such, the judgment and order dated 26/2023 is liable to be reviewed. Only slight modification of the language, my lord. Modified so as to prevent any miscarriage of justice. Where is the miscarriage of justice, my lord? Now, it is not a case that the review petitioner here was not allowed to participate in the selection process. There was no bar. On the other hand, I was affected because I could not compete in the subsequent selection process because there was there was an age bar, my lord. So I was more affected. For that it is the ground number 3, all the grounds, my lord. Ground number 3, for that it is a settled position of law that a decision of a case cannot be based on grounds outside the pleadings of the parties, and it is to be pleaded, it is the pleaded case that it has to be found without any amendment of the plaint. The Honorable Court could have granted relief, not asked for and especially when no prayer was ever made to amend the plaint so as to incorporate it an alternate case. In any view to the contrary would be against the settled position of law. So, my lord, here he is questioning this very decision of this honorable court. Now, that same court, it cannot be questioned, my lord.
Why not? In review, that's the law.
My lord, then, no, my lord, review, there has to be an error apparent on the face.
Exactly.
What is the error, my lord? Exactly. This is not an error. This cannot be termed to be an error.
Yeah, that would be your contention.
Yes, my lord.
That will be looked into. But to say that the petitioner is, debarred from questioning
and
the
my lord,
court judgment, that is...
There is also a question of delay in laches, my lord. Now, here is a case where a third party right has already arisen. There is no challenge to the new advertisement. It is not a case, you have not challenged the new advertisement. You have not challenged the new appointment. By filing a review, how is it going to improve the situation, my lord? The March water has already flown.
All these contention that you have raised, you have to substantiate it by relevant authorities.
Yes, my lord.
So you do that.
I have the relevant authorities. Then if I am allowed to take to just one more paragraph, my lord. Page 13, para 6, my lord. For that the petitioner in the instant case has been penalized for no fault of hers, and in the facts and circumstances of the entire case, the petitioner, who was a bona fide applicant to the advertisement so published by the respondents and met all the criteria and eligibility under the said advertisement, was made to suffer for the alleged act of omission and commission on the part of the respondents. The petitioner, being at no fault and her appointment being quashed for the alleged act of the respondents, therefore has approached this honorable court seeking review of the judgment and order dated so and so passed by this honorable court in the interest of justice. Now, my lord, will also kindly see, it is not the case, it is not a case that the petitioner was not heard. Petitioner had filed, in fact, my lord, petitioner, the affidavit was filed after 4 or 5 years. It is lucky that I did not press for ex parte order against the review petitioner, my lord. The affidavit was filed at the fag-end, sometime in the year 22 or 23, my lord, whereas the case was filed in 2015. So it is not a case that petitioner was not given her due chance to argue the matter, my lord. All these facts are already argued before this.
But that consideration was to be raised, at the
my lord, it is
initial stage.
What my friend is stating, because it is not a fact that these points were not argued. These facts were already argued, my lord. It cannot be revisited by a review. Whatever points my friend is raising, these are already argued before this honorable court. Hence, it is also reflected in the honorable court's order. It is not a case that there is no this fact is not reflected in the honorable court's order. So it is a clear indication, my lord, that this honorable court gave a very thoughtful consideration to all that. Why again a rehearing on this matter? That cannot be a ground of review. And in fact, my lord, my friend had fairly considered also. In fact, he had also suggested that there should be a fresh selection process before this honorable court.
That is reflected in the impure order.
My lord, if I am allowed to take my lord to para 44 onwards, my lord, of the judgment of this honorable court.
Page?
This is, I'll be allowed. My lord, if I am allowed to take my lord to from page 102 onwards, my lord, if I am allowed to read.
Yes.
In a similar vein, the learned counsel for the respondent number 9 has also submitted that when the advertisement came out, the said respondent being qualified to apply for the same have done so. 102 have done so. It was only in course of these proceedings that it transpired that according to the NCT norms, having B.Ed degree is the qualifying criteria for a candidate to apply for the post of assistant teacher in deficit secondary schools. Therefore, the respondent number 9 having been selected, she cannot be faulted for not being aware of the qualifying criteria in the said selection process. The court having observed that this is a very peculiar situation, faulty right from the inception. My lord, will kindly see the conclusion of this honorable court. Thus, giving a false impression to aspirants who are seeking meaningful employment and perhaps a fulfillment of sorts by being engaged in the teaching profession, would hold that fault would lie entirely with the said Rajawala Higher Secondary School and then the education department. The school, in spite of being a school under the deficit system, meaning thereby the financial grants is received from the government, thus rendering itself bound by certain rules and regulations are applicable, which are issued by the education department, has failed to make this fact known, that is, that a possession of B.Ed degree is an essential qualification while getting the advertisement published, is thus liable. My lord, will kindly see the conclusion of this honorable court. Getting the advertisement published is thus liable for having the entire process scrapped. This is the finding. As indicated, the education department, while issuing the impugned letter of approval for appointment of the respondent number 9, more so with the condition that she would get her B.Ed degree within 3 years time after she is appointment, also goes to show that being aware of the said stipulation has sought to condone the same in an indirect manner, which is not in accordance with any rules in this regard and is thus not in conformity with the principles of law. Such an action cannot be condoned by the court. There is no quarrel with the position of law advanced by the learned counsel for the respondent number 8 as well as respondent number 9. All of these matters are already argued. That once a candidate has participated in a selection process, she cannot come before this court after being declared unsuccessful. So, my lord, that refers to me, my lord, the petitioner therein, to challenge the said selection process. The case of Madras Institute of Development Studies, Supra, at paras 12-18, duly being taken note. However, the contention of the petitioner that she came to know of the fact that B.Ed degree essential qualification is also the fact that the respondent number 9, in spite of not having the said qualification of B.Ed degree, was appointed to the said post. Whereas, my lord, I am qualified before the, even while submitting the application, I am already B.Ed. I am having this qualification prior to the advertisement, my lord. Was appointed to the said post of assistant teacher only from the answer to the relevant RTI queries. Naturally, my lord, I will not know whether the other candidate is having requisite qualifications or not. As submitted, the petitioner had known about this anomaly from the beginning. She would have challenged the advertisement. This point is also discussed, my lord. My friend is misleading this honorable court. This argument is found acceptable to this court, considering the fact that nothing was indicated in the said advertisement about B.Ed being an essential qualification to qualify for application of the said post. So, my lord, even that point was exactly gone into, that why you did not challenge the advertisement. Then there is argument is also placed that I did not know that B.Ed is a requisite qualification was not there. Had I known this is the position, I would have challenged it earlier. And the court has taken note. The petitioner, however, cannot make contradictory prayers after challenging the appointment of respondent number 9 on the ground that the same was in gross violation of the provisions of law and the directions of the government of Meghalaya, which appointment was on the basis of the said advertisement to come and say, now appoint me, instead cannot be fathomed by this court, since according to the said advertisement, the petitioner herself not qualified to apply for the said post, given the admission of the petitioner that she has petitioned the secretary of the school to condone her lack of qualification. My lord, because here there was another question raised with regard to Assamese subject, my lord. So to that point, this finding of the court, my lord, having secretary of the school to condone her lack of qualification, not having major in Assamese language, which though was allowed, but again which was not indicated under what rule the same was allowed. The petitioner has annexed a copy of the Gazette of Notification dated so and so September 2001 NCT qualifications for recruitment of teachers in schools, regulations 2001. In these regulations, the minimum academic and professional qualifications for appointment as a teacher in the secondary school level is graduate with B.Ed or its equivalent. It was these regulations which were referred to by the Director of Higher and Technical Education in his communication dated 12/1/2007. Our advertisement is of 2014. This is of 2007. Even 2010 regulations were also there, my lord, by then. Under the NCT Act, National Council for Teachers Education established under Section 3, Subsection 1 is the only authority to prescribe minimum qualification for a purpose to be employed as a teacher in schools or in recognized institutions. Section 12A of the NCT Act provides that National Council may by regulations determine the qualification of persons for being recruited as teachers in any primary, pre-primary, primary, upper primary, secondary, senior secondary or intermediate school or college by whatever name called, established, run, aided or recognized by the central government or the state government or a local or other authority. It need not be reminded that the NCT regulations made under the NCT Act are mandatory in nature. Therefore, the said communication of the Director DHTTE is not an executive or administrative order in a sense, but a conveying of what the mandatory regulation stipulates. So there also the argument was raised that this is mere executive instruction. So this is the finding of the court, my lord, this honorable court, that no, it is not a executive instruction. These answers contention raised by respondent number 8 in the case of Jitendra Kumar and so Supra. Thus, referring to the advertisement dated 6/1/2015, placed in juxtaposition with the relevant provisions of the NCT regulations, the answer to the perceived dilemma can be safely answered by referring to the case of Employees State Insurance Corporation versus Union of India, so wherein at para 20 of the same, the Honorable Supreme Court is held. However, it is a settled principle of service jurisprudence that in the event of a conflict between a statement in an advertisement and service regulations, the latter shall prevail. In Malik Mazhar Sultan versus UP Public Service Commission, a two-judge bench of this court clarified that an erroneous advertisement would not create a right in favor of applicants who act on such representation. My lord, there is a clear finding of this honorable court even in the advertisement, even with regard to the advertisement. This honorable court has gone into detail. My friend is saying that no, prayer is raised, so court. In the process of the hearing, all aspects will have to be gone into by this honorable court, my lord. This honorable court has immense power to even mold reliefs. On an overview of the case of the parties herein, this court convenes that the said advertisement dated 6/1/2015 is an erroneous one. Now, my lord, why it is an erroneous one? It does not prescribe the mandate, the mandated qualification. The applicants will have to have a B.Ed degree qualification. There are all other aspects at this stage I am not going into. But why Assamese language? Because the review petitioner was an Assamese. She did her education in Assamese. Lord, I'll try to find out just one last point before I sit, Lord. what the government has also stated before this Honorable Court. My Lord, may kindly bear with me. In fact, this Honorable Court has discussed in thorough detail, my Lord. My Lord, para 26.
26.
Para 26, page 97, my Lord.
Yes.
What is the summation of my friend, my Lord? My Lord will kindly see.
Yes.
Mr. H. Kharmi, learned additional senior government advocate, has submitted that the crux of the matter is the said advertisement dated 6/1/2015. These issues were already raised before this Honorable Court, wherein the application for the post of Assistant Teacher Arts in Respondent School was brought out in public domain by publishing it in local daily newspapers. It is submitted that apparently the officials of the school involved have failed to note that there are already instructions issued by authorities in the education department to say that for filling up of the post of assistant teacher in a higher secondary school, the required or essential qualification is B.Ed pass, which has been prescribed by the NCT, in absence of which no approval for appointment can be considered. In the case in hand, the approval for the appointment for respondent number 9, that too with a condition that she should acquire the educational qualification of B.Ed degree within 3 years from the date of appointment, is dehouse the rule. This is the submission of the state, my lord, and not in conformity with government's instructions, and as such the appointment of respondent number 9 is not valid. This is the prayer, my lord will can see, and the whole selection process should be scrapped, and the school managing committee may be directed to issue fresh advertisement. My lord, my friend is misleading this honorable court. My lord will kindly see even the stand of the government, what it is said. All these arguments, everything, my lord, this honorable court, the records, everything this honorable court took into consideration to reach that decision, my lord. That decision is not reached by this honorable court out of nowhere, my lord. All these things were thoroughly gone into. This is the request of the government, that yes, there is some fault with that advertisement itself. So the advertisement should go. There should be new advertisement. This is reflected, my lord. So next is the submission of the, my lord, para 29 is the submission of the counsel of the review petitioner, my lord. So they have the same thing, my lord. On the other hand, Mr. Philamon Nongri, appearing for respondent number 9, has submitted that respondent number 9 cannot be faulted for being selected for the post for subsequently being appointed as assistant teacher of Rajabala Secondary School on coming across. So the usual argument which is placed by this, my friend, on coming across the said advertisement and being duly qualified as per essential qualifications listed therein, the respondent number 9 has applied for the post and was legitimately selected for appointment. So the normal argument, my lord. But my lord will kindly see there are observations. There was a request made before this honorable court, the submission of the government council, that no, there is advertisement itself is faulty, so that should be scrapped.
Yes.
It's not necessary that I will have to make a certain pleading only then. My lord, during the course of the hearing, these facts were glaring at before this honorable court, my lord, that why such a thing has happened. So this is a glaring mistake. If this is not removed, then what?
Mr. Jindal, I think your whole case fails here.
I'll address it. I'll address this. Let my friend finish.
30.
I'll address this.
I have made a lot of allegations, my lord. There is also an observation in para 31. So the submissions were thorough submissions. My lord will kindly see para 31. I had also stated, my lord, here, of course, I don't want to go into the fact, but this is all the appointments, everything is within the family, my lord. So that is why para 31 on the allegation of, my lord, these observations, this aspect was also looked into by the Honorable Court. On the allegation of nepotism, the learned counsel for respondent submitted, because there was already an allegation that there was nepotism. My lord, where is the fault? There is no fault. Can it be faulted with? It cannot be. The whole genesis is the advertisement itself. Had the advertisement clarified that all the candidates, whoever, it was mandatory for them for any appointment, along with the advertisement, to state that B.Ed qualification is essential. Now, if that word would have been included in the advertisement, my lord, that B.Ed qualification is essential, the review petitioner would not have been able to compete at all. Madam, will kindly understand the situation. So that she would have been precluded from participating. That is where the concession is there. So my respectful submission, my lord, there is no ground for review made out. Merely stating before this honorable court that there is error apparent on the face of record is not sufficient. The grounds which you have stated here all can be raised in appeal. But however, you never chose to file an appeal either. If required, I may rebut again, but as of now, my lord, and with written arguments, I'll supply some judgment also, my lord, before this honorable court.
Yes, Mr.
Please, Lordship. Lordship, pursuant to the judgment, Lordship, the advertisement was issued and the selection was also conducted and the successful candidates were selected. Now, Lordship, the review has been filed. It is for the review petitioner, Lordship, to show that the judgment requires the interference of this honorable court, Lordship. In the writ petition, Lordship, I have mentioned all the eligibility criteria for a candidate to be appointed as assistant teacher. So, in this review petition also, Lordship, my stand is the same. My stand is the same. So, I leave it to your Lordship and to the review petitioner to satisfy your Lordship that the judgment requires the interference of this honorable court. My stand is the same now.
Please, Lordship, 2 or 3 very quick responses. First, my lord, is the contention of the private respondent that number one, third-party rights have been created, my lord. That counsel for the government has also stated something to that effect, that there has been a selection process which was conducted, etc., leading to selection of a particular person, and therefore third-party rights have been created. Lordship, I beg to differ. Third-party rights cannot and could not have been created, my lord. We are focusing, the respondents, opposite parties are trying to focus the attention of this honorable court only on the advertisement which was issued subsequent to Lordship's judgment. Advertisement, my lord, was issued on 23rd August 2023, my lord, about 2 months after Lordship's judgment. Advertisement by itself does not create any third-party rights. It is the selection of a particular person that may or may not, I'm not even considering anything that is right, may or may not have created third-party rights. Selection of the person was conducted in the midst of the pendency of the review petition. So selection was conducted, if the records can be looked at, on 10th July 2024, when this review petition was still very much alive. And in fact, on 6th July 2024, I had finished my submissions in the first round on the review petition itself. So the third-party rights being created cannot have a play in Lordship's adjudication of this review petition. Third-party rights were created, if at all, with their eyes wide open, knowing fully well that the matter is still sub judice. knowing fully well that it could go.
But Mr. General,
yes,
if I understand or
yes,
if I remember correctly,
yes,
you said that the process of fresh advertisement, the selection process as such has been challenged.
it is under challenge.
It's under challenge.
It is under challenge. Before
Who has challenged this?
Another candidate. This is in WPC number 251 of 2024, and
okay, somebody who was not selected.
Who was not selected in that process, the second process, the second stage. That person has challenged. I believe this WPC number so and so is still pending.
You see, his ground of challenge, whatever,
would be on.
No mention has been made of the previous selection process.
No, my lord.
So this has got no connection at all with.
Absolutely not. Absolutely.
Yes, challenge only the fresh selection.
Yes.
So there's no reference or any sort of power or right derived from the first stage of selection, my lord. Point being, my lord, third party rights have not been created. Number one, even if created, they have been created by the school with their eyes wide open, knowing fully well matters still sub judice. So Honorable Court is still to dispose of this review petition one way or the other. Taking a risk, they have gone ahead.
Was the the Learned Court made?
There was no stay order.
No, was it brought to its notice that this review petition is pending?
Because I'm not a part of that, I cannot answer that question. I'm not sure.
But you should have followed the proceedings. You are there?
He's there. He's appearing for.
Never brought to notice. So that has proceeded independently.
Yes,
independently, my lord. Point being, my lord, if at all there is to be some sort of correlation to be drawn between the two proceedings, that proceeding would be subject to the outcome of today's proceeding. If Lordship agrees with me and Lordship reviews Lordship's judgment, the outcome would be that the writ petition is revived. This writ petition is revived.
See, this, I mean, I fail to understand.
Yes, madam.
Please educate me on this.
Yes, madam. Yes, madam.
It's a peak situation.
Yes, madam.
In as much as, suppose.
Yes, madam.
The other process is complete. Selection has only been done.
Yes, madam.
Somebody has been appointed.
Yes, madam.
Appointment challenge, whatever.
Yes, madam.
And here we have a review petition.
Yes, madam.
To consider the existence.
Yes,
of the previous process.
Yes, madam.
So now what happens?
Now, point being, my lord, that the second process, which is under challenge in the other writ petition, the genesis of that process is the advertisement that was issued in August 2023, based on the liberty that Lordship granted through Lordship's judgment. Now, as I was saying, if Lordship agrees with me and allows the review petition, that judgment will have to be set aside or modified. In other words, the liberty to issue the advertisement will go. Now, once any consequential steps taken pursuant to the liberty, which no longer exists if the review petition is allowed, those will also come to a naught, my lord. Those will also come to a naught. So
but you see, Mr. General.
Yes, ma'am.
Coming back to third party. Yes, third party rights.
Yes, ma'am.
Whoever has been appointed through the subsequent advertisement process or the process.
Yes, ma'am.
Would surely have acquired a right now.
My lord, it's this way. If I can draw a parallel, if I'm allowed to draw a parallel, there is the Transfer of Property Act. Now, under the Transfer of Property Act, section 57, 58, my lord, what happens is, if there is property under litigation, under dispute, if there is some encumbrance on that property, and a seller buys that property, that the property is transferred to the seller with that encumbrance, with that liability, with that charge. So similar is the case here, my lord. Now, in the middle of judicial proceedings, you go ahead and select a person. So advertisement was issued 2023 August. 1 year later, you wait 1 year. 1 year later, in the middle of the review petition, you appoint a person. You are doing so, in other words, you're buying encumbered property. So a person who has entered that post is entering a post which is in a way encumbered, my lord. In a way encumbered. The process has been undertaken. The selection process has been undertaken with the risk attached, with the risk that maybe at some point the advertisement itself, based on which that second selection process was initiated, would would no longer be in existence, my lord. So that being the case, third-party rights having been created, I would have to differ with that, because even if created, even if it is assumed to be created, they were created with knowing the risks fully well, my lord, knowing the risks fully well. And I would also have to humbly point out, respectfully point out, that that selection process.
Mr. General,
yes,
you say knowing the risk fully well.
Yes, ma'am.
For discussion's sake.
Yes, ma'am.
Now it would be, the risks would be only on account of the relevant authorities, setting the whole thing to motion.
Yes, ma'am.
But as far as the selected person
yes,
is concerned,
yes, ma'am,
he or she has no knowledge of all this.
Yes, ma'am. In that case, I would say,
why would you consider him, to be in the know?
Yes, my lord. In that case, my lord, I would have to humbly submit that the relief available to that affected person, the selected candidate whose selection is under challenge, that that person's relief would lie against the school, my lord, because it is the school. It is the school who has appointed her to a post which the school knows is under threat. Now, having done so, and finally it comes to a situation where she is out of a job. In that case, her relief, damages or whatever it is that is allowed under law, would lie against the school, my lord, because it is the school which has offered that post to her, knowing fully well the risks involved with that post, my lord. Now, so third-party rights, whether they exist or not, that is debatable. But in any event, my lord, that cannot have I would submit that cannot have a play in today's proceedings, my lord. Number one. Number two, my lord. My friend Mr. KP has taken a lot of effort in taking Honorable Court through the judgment, my lord. Now, the attempt is very clear. The attempt is to try and impress upon this Honorable Court that the matter has been heard fully, my lord. To an extent, I agree with my friend. I agree that the matter was argued, the matter was heard, and the matter was decided. But I remain firm in my original submission. The issue of the advertisement was not argued. The issue of the advertisement was not heard. The issue of the advertisement should not, therefore, have been decided, my lord. My friend has taken this Honorable Court to the submissions of the Government Council, that is at para 26, my lord. Now, what exactly is the submission may kindly be looked at? Para 26, Mr. H. Karmi, learned additional senior government advocate, has submitted that the crux of the matter is the said advertisement dated so-and-so, wherein application for the post of assistant teacher arts in the respondent school was brought out in public domain by publishing it in the local daily newspapers. Full stop. So, first, he just states that the crux of the matter is the advertisement. Crux of the matter, of any selection matter, is the advertisement, naturally, my lord. There is no nothing spectacular in the submission, my lord. It is an admitted fact. Crux of any selection process is the advertisement that is issued. Subsequently, my lord, the subsequent paragraphs, is there any discussion or submission on the advertisement? Nothing, my lord. So to say that the advertisement is the crux of the matter cannot be magnified and to try and project that advertisement was discussed, was argued upon, was heard upon. Nothing. It was mentioned. There's no running away from that fact, but it was never heard. It was never, and the black and white record reveals it was never pleaded, my lord. And the law is very clear. If you do not plead it, you can argue it. But would that enable the Honorable Court to give any relief? I would say no, my lord. I would say no. My friend made a very interesting submission that the government advocate had requested this Honorable Court that the advertisement should be set aside. I could not find that request anywhere. But even assuming that there is some sort of request from the Government Council to set aside the advertisement, can a judgment be passed on a request, my lord? It has to be passed on pleadings, my lord. On pleadings, more so, I would say, in a writ proceeding where no evidence, etc., is there. It is only the pleadings which is the foundation on which the judgment stands, my lord. And the pleadings are clear. There is no reference to the advertisement, my lord. My last point, and it is a request, my lord. It is a request for this Honorable Court to kindly appreciate whether my friend appearing for the original writ petitioner stands on any legs to oppose this review petition. This is for the reason that I would say, does he have the locus to review this review petition or to oppose this review petition? Does he have any legs to object to this review petition? Why does he want to object to this review petition? Why I say this is because if I succeed, what happens is Lordship's judgment is modified or set aside or recalled. That means the writ petition, his writ petition is revived. If his writ petition is revived, then what happens? He gets a second bite at the apple. His prayer to be appointed is revived. Maybe in the second round of hearing, this Honorable Court may be convinced he may have a chance of being appointed to the position. Point is very simple, my lord. Why is my friend objecting to this review petition? It helps him. It helps him for the reason that his writ petition is revived. Does he not want his writ petition to be revived? If the answer is no, then the motives have to be examined. Why, having filed a writ petition is dismissed. Now there's an opportunity for the writ petition to be revived, for you to get another chance, another bite of the apple. You want to object to that? On what grounds? On what legs, my lord? I close my submissions, my lord.
Mr. General, yes, yes, perhaps you have taken the words out of my mouth.
Yes, my lord.
I was about to make the same query.
Yes,
but the fact remains.
Yes, madam.
You have arrayed him as a respondent.
I have to, my lord.
It's incumbent, whether you have to or you don't have to. You have arrayed him as a respondent.
Absolutely.
He has to respond.
Absolutely, my lord. I would have
this way or that way. He has to respond.
I have to. I agree. I would have expected. I would have hoped that he would have supported me because I am trying to revive his writ petition. Okay. I would have expected that, my lord, under normal circumstances. But circumstances.
You can't rely on supposition.
My assumption was incorrect, my lord. I shouldn't have assumed too much, my lord. But in any event, my lord, if lordship is giving my friend an opportunity to file some written arguments, I'll file some bullet points also, my lord. That's all. Obliged, my lord. Obliged.
Responding to just the contention of my friend regarding, my lord, why I am objecting so much. My lord, if, no doubt, if this petition is revived, what happens is that, my lord, the position of the review petitioner as the teacher of the school is also revived. He is not interested in me, my lord. He is not interested in reviving. He is interested in his position. The petitioner is interested in reviving her position. I am just only a mere excuse, my lord. Now, as far as the fresh advertisement, my lord, that was brought on record by my affidavit. Even the managing committee has filed affidavit before this honorable court, my lord, regarding the fresh selection process.
Was rejoinder filed?
Rejoinder was not filed, my lord.
Not filed.
And bringing the new fact before the notice of this honorable court.
You have to point out, you see, because your counter is pleading in itself.
Yes, in my counter I have in detail I have stated, my lord, in my counter affidavit, and I have enclosed the advertisement also, which is at Annexure 1. My lord.
Where is it?
My affidavit in opposition, which is filed before this honorable court, and thoroughly in detail I have given, my lord. Advertisement is enclosed at the last page, my lord, page 14. In my affidavit.
You should have pointed out, in course of your.
No, my lord, because I was going strictly by whatever my friend was submitting. So this is there in the record, my lord. Advertisement.
We are discussing, or rather, trying to find out whether any error apparent on the face of the record, or some facts which ought to be there is not there for the court to to exercise its review jurisdiction. Mr. Jinder has made his point. Court will consider that. You have also made your submission, but you have not really pointed out that it's part of the pleadings.
It's part of the pleadings.
If that is the case, then
it's part of the pleadings. I filed an affidavit.
Perhaps there's the whole case assumes a different significance now.
Lordship, in the writ petition, Lordship, my main submission was mainly on the eligibility criteria of the candidates.
True.
In the writ petition. So at the time of the earlier selection, both of them.
Review writ petition.
Lord, review. It is already enclosed in the review.
It's enclosed in the review. Which page?
You're talking about which one?
Your counter.
My counter is here, my lord. My counter to the review petition is
Not your counter to the review or your counter to the writ.
I had filed no, my lord, read in the
Oh, sorry. You are the petitioner.
petition. I was the petitioner.
Okay.
I have also filed my rejoinder, my lord.
Yes, in your rejoinder,
Yes.
you have made reference to the advertisement. You said you have filed a copy of the advertisement. Made
No,
reference?
I'm talking about this advertisement, my lord, the fresh, new
Oh,
advertisement.
fresh. Yeah, talking about the previous one.
No, my lord. I'm talking about the new advertisement.
In the previous one, both of them, they did not have the eligibility criteria.
True.
My lord, I had the eligibility.
Both of them. They do not have the eligibility criteria.
Well, that is a different thing. But
That's why it was set aside.
the fact that the fact remains that was it ever been, has it ever been brought to the notice of this court by way of an affidavit?
My lord,
What issue?
my lord, in page 68, 67 of my rejoinder, I have stated in detail. That is, of course, in the which is also enclosed in the review petition. My lord.
What issue is it?
This is regarding the advertisement. And my lord will kindly see.
You go through the records and file your written argument.
Yes.
If that is the case, then I have to see.
My lord.
Perhaps you must have produced the entire records.
Yes, my lord. My review petition contains all the pleadings,
No,
etc.
not in the review. As far as the writ petition is concerned.
Yes, my lord.
If what he says is correct, that's somewhere along the way.
Yes, my lord.
This fact has been brought to the notice of this court by way of the counter, rejoinder, whatever.
My lord,
Even
the fault is
in fact, the discussion
the
is
fault
that-
is mine, but I could not really get what advertisement, what is the point?
He was talking about the previous advertisement.
The first advertisement.
No, I've also brought on record the fresh advertisement.
The first advertisement.
Fresh,
And
not
fresh
on the fresh
my lord, the
advertisement.
first advertisement is part of the record.
It's part of the record. It's part of the
part of the writ petition.
writ petition, my lord.
This is already a part
It's
of the
part of the
record,
writ
my lord.
petition.
It is not. I have placed. This is a part of the writ petition, my lord. How can I file a writ petition without having the advertisement, my lord? And about the fresh selection process, my lord will kindly see there was no stay order of this honorable court. Secondly, my lord. Secondly,
As far as that aspect is concerned, if you have authorities in that regard,
my lord,
just bring it out. That consequent to an order pass, certain actions have been taken by the authorities. That itself has created a third party right to somebody, and that would in turn be rather this review petition would be an impediment to that process, and so on and so forth. And we'll see.
my lord, what if
Lordship, one thing, the fresh advertisement, Lordship, it was not in the picture during the writ petition, Lordship.
Obviously.
It was pursuant after the judgment.
fresh
After the
advertisement.
judgment.
Of course, that has been pointed out.
No.
That there's no quarrel there.
My lord will may kindly appreciate. Now, the court where the new fresh writ petition is filed, my lord. Now there the court comes to a finding that the appointment of the new candidate is legitimate, legal, nothing is wrong. And my lord, here there is a different review in the decision in the review, my lord. Then that will totally, my lord, it could create a lot of confusion, my lord.
Conflict of orders will not arise for the simple reason that honorable court will pass an order on this review petition within the next some time.
And number two,
That
my lord.
petition is still in the nascent stage, my lord.
No, number two. Number two is that, my lord, there was never a prayer made before this honorable court to stay the proceedings, the fresh selection process, fully knowing that she is also part of it.
Maybe it could not have been done so. So I thought the
Review
parties.
petition, Lordship, is for the review petitioner to show that there is some requires interference. It's
You'll file your
between the
written
court and the review
Bullet
petitioner.
points. I will not make extensive summary. Short bullet points, my lord. Within a week, my lord.
You are also there. You.
Respondent number 8 and 9.
Who are you?
School.
Oh, then you have not been heard. You are required to be heard. You may have filed your affidavit, but now we are at the stage of hearing. So whether you would like to be heard or you endorse the...
I'll adapt his argument, Your Lordship, and at the same time I'll file my final
argument. That you can do. That you can do. Heard Mr. Espinal, Learned Counsel for the Review Petitioner. Also heard Mr. K.P. Bhattacharjee, Learned Counsel for the Respondent number.
My Lord, I am Respondent number
9.
My Lord, I am 7, my Lord.
Respondent number 7. And Mr. K.P. Bhattacharjee, Mr. H. Karmi, and Senior Additional.
I am for the Respondent 1 to 6, Lord.
For Respondent 1 to 6 state. Ms. B. Ghosh, Learned Counsel for Respondent 8 and 9 has adopted the argument of the Respondent number 7. The parties have made further submission to allow them to file brief written synopsis of their argument along with relevant authorities relied upon. Pray along. This is matter after 1 week.
1 week.
2 weeks. There is holiday also in between.
Oh yes, 2 weeks.
Obliged.
Thank you.